हेलो एवरीवन। टारगेटेड जुडिशरी चैनल पे आप सभी का स्वागत है। आज के भी इस वीडियो में हम सेक्शन 52 से स्टार्ट करेंगे। सो हेडिंग है कैरेक्टर व्हेन रिलेवेंट। 52 का जो टाइटल है वो है इन सिविल केस कैरेक्टर टू प्रूव कंडक्ट इम्प्यूटेड इररिलेवेंट। यानी कि किसी भी मामले में किसी सिविल मामले में अध्यारोपित आचरण को साबित करने के लिए सील जो है वो विसंगत है, इररिलेवेंट है। In civil cases, the fact that the character of any person concerned is such as to render probable or improbable any conduct imputed to him is irrelevant, except in so far as such character appear from fact otherwise irrelevant. अब है 53 का जो सेक्शन है कि क्रिमिनल केसेस में प्रीवियस गुड कैरेक्टर जो है वो रिलेवेंट है। क्रिमिनल प्रोसीडिंग द फैक्ट दैट द पर्सन एक्यूज्ड इज ऑफ ए गुड कैरेक्टर इज रिलेवेंट। 53 का ए है, उसमें है कि एविडेंस ऑफ कैरेक्टर और प्रीवियस सेक्सुअल एक्सपीरियंस नॉट रिलेवेंट है इन सर्टेन केसेस। इन प्रोसिक्यूशन फॉर एन ऑफेंस अंडर सेक्शन 354, 354 ए, 354 बी, 354 सी, 354 डी, 376, 376 ए, 376 ए बी, 376 बी, 376 सी, 376 डी, 376 डी ए, 376 डी बी एंड सेक्शन 376 डी ई 376E of the IPC, or for attempt to commit any such offense when the question of the consent is in issue, evidence of the character of the victim or of such person's previous sexual experience with any person shall not be relevant on the issue of such consent or the quality of consent. 54 का है कि previous bad character not relevant except in reply. So in criminal proceeding, the fact that the accused person had a bad character is irrelevant unless evidence has been given that he has a good character, in which case it become relevant. The section does not apply to cases in which the bad character of any person is itself a fact in issue and a previous conviction is relevant as evidence of a bad character. Next है 55 character as affecting damage. In civil cases, the fact that the character of any person is such as to affect the amount of damage which he ought to receive is relevant. In section 52, 53, 54, 55 the word character जो है वो include करता है both reputation and disposition, but except as provided in section 54, evidence may be given only of general reputation and general disposition and not of particular act by which reputation or disposition were shown. So ये सिंपल सा था, 3-4 इसमें सेक्शंस है कैरेक्टर वाले में, ये हमारे कंप्लीट हो गए हैं। बाकी का हम करेंगे हमारे यहाँ पे नेक्स्ट जो है सेक्शन 56 से स्टार्ट। पार्ट सेकंड स्टार्ट हो जाता है ऑन प्रूफ, चैप्टर 3 फैक्ट विच नीड नॉट टू बी कवर्ड। तो कौन से फैक्ट है उनको कवर करने की प्रूव करने की ज़रूरत नहीं है। एक तो सेक्शन 56 में है कि ऐसे फैक्ट जो जुडिशली नोटिसेबल है उनको ज़रूरत नहीं है यहाँ पे प्रूव करने की। तो नो फैक्ट ऑफ विच द कोर्ट विल टेक जुडिशियल नोटिस नीड बी प्रूव्ड। तो इम्पोर्टेंट है टाइटल। 57 का है कि फैक्ट ऑफ विच कोर्ट मस्ट टेक जुडिशियल नोटिस। The court shall take judicial notice of the following fact. First, all laws in force in the territory of India, all public act passed or hereafter to be passed by Parliament of the UK, उस टाइम बना था एक्ट इसलिए all public act passed or hereafter to be passed by Parliament of the UK and all local and personal act directed by Parliament of the United Kingdom to be judicially noticed. नेक्स्ट है आर्टिकल ऑफ वार फॉर द इंडियन आर्मी, नेवी और एयर फोर्स। नेक्स्ट है 4 The course of proceeding of Parliament of the UK, of the Constituent Assembly of India, of Parliament and of the legislature established under any law for the time being in force in a province or in the states. The accession and the signed manual of the sovereign for the time being of the UK, of Great Britain and Ireland. तो एक्ट पहले का है इसलिए यहाँ पे ये लैंग्वेज यूज है। नेक्स्ट है द सील्स ऑफ विच इंडियन इंग्लिश कोर्ट्स टेक जुडिशियल नोटिस, द seals of all the courts in India and of all courts out of India established by the authority of the central government or the crown representative, the seal or court or admiralty and maritime jurisdiction and of notaries public, and all seals which any person is authorized to be used the constitution or an act of parliament of the UK or an act of regulation having the force of law in India. The accession to office, names, title, function, and signature of the person filling for the time being any public office in any state, if the fact of their appointment to such office is notified in any official gazette, the existence, title, and national flag of every state or sovereign recognized by the government of India, the division of time, the geographical division of the world, and the public festival, fast, and holiday notified in the official gazette, and the territories under the dominion of the government of India, the commencement, continuance, and termination of hostilities between the government of India and any other state or body of the person, and the name and the names of the members and office of the court and of their deputies and subordinate office and assistants, and also of all officers acting in execution of its process, and of all advocates, attorney, protector, proctors, and vakils, pleaders, and other person authorized by law to appear or act before it, and the rule of the road on land or at sea in all these cases, and also on all matter of public history, literature, science, or art. The court may resort for its aid to appropriate book or document or of reference. If the court is called upon by any person to take judicial notice of any fact, it may refuse to do so unless and until such person produce any such book or document as it may consider necessary to enable it to do so. इसके अलावा फैक्ट एडमिटेड एंड नीड नॉट टू बी प्रूव्ड, तो हम देख रहे थे कि कौन से यहाँ पे जो फैक्ट्स हैं उनको प्रूव नहीं करने की जरूरत होती। तो एक हमने देखा था कि फैक्ट जुडिशियली नोटिसेबल नीड नॉट टू बी प्रूव्ड, ये 56 में देखा था। 57 में देखा था कि फैक्ट ऑफ विच कोर्ट मस्ट टेक जुडिशियल नोटिस, एंड लास्ट है फैक्ट एडमिटेड, जो एडमिट करे जा चुके हैं उनको प्रूव करने की जरूरत नहीं है, ये है 58। नो फैक्ट नीड टू बी प्रूव्ड इन एनी प्रोसीडिंग विच द पार्टीज देयर टू और देयर एजेंट्स एग्रीज टू एडमिट एट द हियरिंग, or which before the hearing they agree to admit by any writing under their hands, or which by any rule of pleading in force at the time they are deemed to have been admitted by their pleadings, and provided that the court may in its discretion require the fact admitted to be proved otherwise than by such admissions। अब है चैप्टर 4 ऑफ ओरल एविडेंसेस, मौखिक साक्ष्य के बारे में दिया है 59 में। प्रूफ ऑफ फैक्ट्स बाय ओरल एविडेंस, मौखिक साक्ष्य के द्वारा तथ्यों को साबित किया जाना। सेक्शन 59 याद रखना है। प्रूफ ऑफ फैक्ट्स बाय ओरल एविडेंस, ऑल फैक्ट एक्सेप्ट द कंटेंट ऑफ डॉक्यूमेंट और इलेक्ट्रॉनिक रिकॉर्ड्स में बी प्रूव्ड बाय ओरल एविडेंस। तो दस्तावेजों के सिवाय सभी तथ्य मौखिक साक्ष्य के द्वारा साबित किए जा सकेंगे। तो दस्तावेज तो लिखित फॉर्म में होते हैं, उसके अलावा जो फैक्ट्स हैं वो ओरल एविडेंस के रूप में प्रूव किए जा सकते हैं। नेक्स्ट है 60, इम्पोर्टेंट है 60 वाला। ओरल एविडेंस मस्ट बी डायरेक्ट होने चाहिए। ओरल एविडेंस मस्ट इन ऑल केसेस वॉट एवर बी डायरेक्ट, दैट इज टू से इफ इट रेफर्स टू ए फैक्ट विच could be seen, it must be the evidence of a witness who says he saw it। अगर ऐसा हो कि यदि वह किसी देखे जा सकने वाले तथ्य के बारे में है तो ऐसे साक्षी का साक्ष्य होगा जो कहता है कि उसने उसे देखा। नेक्स्ट है अगर सुनने वाला हो तो इट मस्ट बी द एविडेंस ऑफ ए विटनेस, जो ये बोलेगा कि उसने उसे सुना। If it refers to a fact which could be perceived by any other senses or in any manner, it must be the evidence of a witness who say he perceived it by that sense or in that manner। यदि वह किसी ऐसी तथ्य के बारे में जिसका किसी अन्य इंद्रिय के द्वारा या किसी अन्य रीति से बोध हो सकता था, तो ऐसे साक्षी का ही साक्षी होगा जो कहता था कि उसने उसका बोध इस इंद्रिय के द्वारा उस रीति से किया। नेक्स्ट है इफ इट रेफर्स टू एन ओपिनियन और टू ग्राउंड्स ऑन विच दैट ओपिनियन इज हेल्ड, इट मस्ट बी द एविडेंस ऑफ द पर्सन हु होल्ड द ओपिनियन ऑन दोज ग्राउंड। यदि वह किसी ऐसी राय के बारे में, उन आधारों के बारे में जिन पर राय धारित है बारे में है, तो उस व्यक्ति का ही साक्ष्य होगा जो वह राय उन आधारों पर धारण करता है। Next, provided that the opinion of experts expressed in any treatise commonly offered for sale and the ground on which such opinion are held may be proved by the production of such treatise, and if the author is dead or cannot be found or has become incapable of giving evidence or cannot be called as witness without an amount of delay or expense which the court regard as unreasonable। परंतु विशेषज्ञों की जो राय हैं जो सामान्य विक्रय के लिए प्रस्थापित की जा सकने वाली किसी पुस्तक में अभिव्यक्त हैं और वे आधार जिन पर ऐसी राय आधारित है, यदि रचयिता मर गया है या मिल नहीं सकता है या साक्ष्य देने में असमर्थ हो गया है, तो वह उसे इतने विलंब या व्यय के बिना जितना न्यायालय अयुक्तियुक्त समझता है साक्षी के रूप में बुलाया नहीं जा सकता और ऐसी पुस्तकों को पेश करके साबित किया जा सकेगा। Next, I provided also that if oral evidence refers to the existence or condition of any material thing other than document, the court may, if it thinks fit, require the production of such material thing for its inspection। परंतु यह है कि यदि मौखिक साक्ष्य दस्तावेज से भिन्न किसी भौतिक चीज के अस्तित्व या दशा के बारे में, तो न्यायालय अगर ठीक समझता है तो ऐसी भौतिक चीज को अपने निरीक्षण के लिए मंगवा सकेगा। नेक्स्ट है चैप्टर 5 ऑफ डॉक्यूमेंट्री एविडेंस। इसमें है 61 proof of content of documents। The content of documents may be proved either by primary और secondary evidence। तो important ऐसा भी पूछ सकते हैं डायरेक्ट, तो प्राइमरी या सेकेंडरी दोनों से प्रूव किया जा सकता है। अगला है 62 प्राइमरी एविडेंस क्या होते हैं भाई। 62 में है प्राइमरी एविडेंस। Primary evidence means the document itself produced for the inspection of the court। यानी प्राथमिक साक्ष्य से न्यायालय के निरीक्षण के लिए पेश किए गए दस्तावेज खुद अभिप्रेत है स्वयं। When a document is executed in several parts, each part is primary evidence of the document। Where a document is executed in counterpart, each counterpart being executed by one or some of the parties only, each counterpart है वो primary evidence होगा as against the party executing it। Explanation second में है कि where a number of documents are all made by one uniform process, as in the case of printing, lithography and photography, each is primary evidence of the content of the rest। But where they are all copies of a common original, they are not primary evidence of the content of। तो कब नहीं होंगे, जब they are all copies of a common original, they are not primary evidence of the content of the original। अब है a person is shown to have been in possession of a number of placards all printed at one time from one original। Any one of the placard is primary evidence of the content of any other, but no one of them is primary evidence of the content to the original contents of the original। तो ये दर्शित किया जाता है कि एक ही समय में एक ही मूल से मुद्रित अनेक प्ले कार्ड किसी व्यक्ति के कब्जे में है। अब इन प्ले कार्डों में कोई भी एक अन्य किसी की भी अंतर वस्तु का प्राथमिक साक्ष्य है, किंतु उसमें से कोई भी मूल की अंतर वस्तु का प्राथमिक साक्ष्य नहीं है, ओरिजिनल का साक्ष्य नहीं है। नेक्स्ट है सेकेंडरी एविडेंस 63। अब सेकेंडरी एविडेंस मीन्स एंड इंक्लूड सर्टिफाइड कॉपीज गिवन अंडर द प्रोविजनल हेयर इन कंटेंट। तो ध्यान रखना है सर्टिफाइड कॉपीज। इसके बाद कॉपीज मेड फ्रॉम द ओरिजिनल, तो ये सेकेंडरी एविडेंस हो गए। बाय मैकेनिकल प्रोसेस विच इन देमसेल्फ इंश्योर द एक्यूरेसी ऑफ दैट कॉपी एंड कॉपीज कंपेयर्ड विद सच टॉपिक्स। कॉपी मेड फ्रॉम और कंपेयर्ड विद द ओरिजिनल, तो ओरिजिनल है वो तो प्राइमरी हो ही गई और उससे बनाए जा रहे हैं वो सेकेंडरी में आ जाएंगे। काउंटर पार्ट ऑफ डॉक्यूमेंट एज अगेंस्ट द पार्टीज हु डिड नॉट एग्जीक्यूट देम। Counterpart of document as against the party who did not execute them, and oral account of the content of a document given by some person who has himself seen it। illustration दिया है कि एक फोटोग्राफ है, a photograph of an original is secondary evidence of its content। ओरिजिनल का फोटोग्राफ है इसलिए वो सेकेंडरी एविडेंस हो जाएगा of its content to the two have been not compared if it proved that the thing photographed was the original। A copy compared with a copy of a letter made by a copying machine is secondary evidence of the content of the letter if it's shown that the copy made by the copying machine was made from the original। Next है a copy transcribed from a copy but afterward compared with the original is secondary evidence, but the copy not so compared is not a secondary evidence of the original although the copy from which it was transcribed was compared with the original। Neither an oral account of a copy compared with the original nor an oral account of a photograph or machine copy of the original is secondary evidence of the original। तो ना तो मूल से तुलनाकृत प्रति का मौखिक वृत्तांत और न ही मूल के प्रति फोटोचित्र या यंत्रकृत प्रति का मौखिक वृत्तांत मूल का द्वितीयक साक्ष्य है। इस वाले को याद रखना है। अगला है 64 proof of document by primary evidence। Document must be proved by primary evidence except in cases herein after mentioned। 65 का है cases in which secondary evidence relating to documents may be given. तो secondary evidence may be given to the existence, condition or content of a document in the following cases. पहला तो है when the original is shown or appear to be in the possession or power of the person against whom the document is sought to be proved, of any person out of reach or not subject to the process of the court, and any person legally bound to produce it, and when after the notice mentioned in section 66 such person does not produce it. Next, when the existing condition or content of the original have been proved to be admitted in writing by the person against whom it is proved or by his representative in interest, or when the original has been destroyed or lost, or when the party offering evidence or of its content cannot for any other reason not arising from his own default or neglect produce it in reasonable time. अगला है when the original is of such a nature as not to be easily movable. अगला है when the original is public document within the meaning of section 74. When the original is document of which a certified copy is permitted by this act or by any other law in force in India to be given in evidence. या फिर when the original consists of numerous account or other account which cannot conveniently be examined in court and the fact to be proved is the general result of the whole collection, तब प्रूव किया जा सकता, तब पेश किया जा सकता है सेकेंडरी एविडेंस. दिया है कि ए सी डी केस में एनी सेकेंडरी एविडेंस ऑफ द कंटेंट ऑफ द डॉक्यूमेंट इज एडमिसेबल. केस बी में रिटन एडमिशन इज एडमिसेबल. एंड ई एंड एफ में, अब बी वाला था यहाँ पे राइटिंग बाय द पर्सन, इसमें रिटन वाला एडमिसेबल है. एंड ई एंड एफ में सर्टिफाइड कॉपी ऑफ द डॉक्यूमेंट बट नो अदर काइंड ऑफ सेकेंडरी एविडेंस इज एडमिसेबल, ई एंड एफ में. And G में evidence may be given as the general result of the documents by any person who has examined them and who is skilled in the examination of such documents. अगला है 65A. Special provision as to evidence relating to electronic record. The content of electronic record may be proved in accordance with the provision of section 65B. ये वाला पूछा हुआ है. एडमिसिबिलिटी ऑफ इलेक्ट्रॉनिक रिकॉर्ड 65B में है. Notwithstanding anything contained in this act, any information contained in an electronic record which is printed on paper, stored or recorded or copied in optical or magnetic media produced by a computer, hereinafter referred to as the computer output, shall be deemed to be also a document if the condition mentioned in this section are satisfied in relation to the information and computer in question, and shall be admissible in any proceeding without further proof or production of the original as evidence or any content of the original or any fact is stated therein or which direct evidence would be admissible. Second, the condition referred to in subsection first in respect of a computer output shall be the following, namely, पहला है the computer output containing the information was produced by the computer during the period or which the computer was used regularly to store or process information for the purpose of any activities regularly carried on our end that period by the person having lawful control over the use of the computer. And second, that during the said period information of the kind contained in the electronic record or of the kind from which the information so contained is derived was regularly fed into the computer in the ordinary course of the said activities. And third is that throughout the material part of the said period the computer was operating properly, or if not, then in respect of any period in which it was not operating properly or was out of operation during that part of the period was not such as to affect the electronic record or the accuracy of its content, and the information contained in the electronic record reproduced or is derived from such information fed into the computer in the ordinary course of the said activities. And third is where our any period the function of storing or processing information for the purpose of an activity regularly carried and over the period as mentioned in clause A of subsection 2 was regularly performed by computer, whether by a combination of computer operating over the period or by different computer operating in succession over the period, or by different combination of computer operating in succession over that period, or in any other manner involving the successive operation over the period in whatever order of one or more computer and one or more combination of computer, all the computer used for the purpose during that period shall be treated for the purpose of this section as constituting a single computer, and reference in this section to a computer shall be construed accordingly in any proceeding where it is desired to give a statement in evidence by virtue of this section is certified doing any of the following things, that is to say, identifying the electronic records containing the statement and describing the manner in which it was produced, and giving such particular of any device involved in the production of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer, and dealing with any of the matter to which the condition mentioned in subsection 2 relate, and purporting to be signed by a person occupying a responsible official position in relation to the operation of the relevant device or the management of the relevant activity, whichever is appropriate, shall be evidence of any matter stated in the certificate, and for the purpose of this subsection it shall be sufficient for a matter to be stated to the best of the knowledge and belief of the person stating it. And the fifth is, for the purpose of this section, information shall be taken to be supplied to a computer if it is supplied thereto in any appropriate form, and whether it is so supplied directly or with or without human intervention by means of any appropriate equipment, and whether in the course of activities carried on or by any official information is supplied with a view to its being stored or processed for the purpose of those activities by a computer operated otherwise than in the course of those activities, that information if duly supplied to that computer shall be taken to be supplied to it in the course of those activities. A computer output shall be taken to have been produced by a computer, whether it was produced by it directly or with or without human intervention by means of any appropriate equipment. For the purpose of this section, any reference to information being derived from other information shall be a reference to its being derived therefrom by calculation, comparison, and any other process. तो title important है इसका. Next है 66 rules as to notice to produce. 66 rule as to notice to produce. Secondary evidence of the content of the document referred in the section 65 clause A shall not be given unless the party proposing it to give such secondary evidence has previously given to the party in whose possession or power the document is, or to his attorney or pleader such notice to produce it as is prescribed by law, and if no notice is prescribed by law, then such notice as the court consider reasonable under the circumstances of the case, provided that such notice shall not be required in order to render secondary evidence admissible in any of the following case or in any other case in which the court thinks fit to dispense with it. First, when the document to be proved is itself a notice. Second, when from the nature of the case the adverse party must know that he will be required to produce it. And third, when it appear or is proved that the adverse party has obtained possession of the original by fraud or force. And fourth is when the adverse party or his agent has the original in court, and when the adverse party or his agent has admitted the loss of the document, and when the person in possession of the document is out of reach or not subject to the process of the court. अगला है proof of signature and handwriting of person alleged to have signed or written document produced. 67. If a document is alleged to be signed or to have been written wholly or in part by any person, the signature or the handwriting of so much of the document as is alleged to be in that person's handwriting must be proved to be in his handwriting. 67A. इसमें है proof as to electronic signature, except in the case of say secure electronic signature, if the electronic signature of any subscriber is alleged to have been affixed to an electronic record, the fact that such electronic signature is the electronic signature of the subscribed must be proved. 68 may have proof of execution of document required by law to be attested. If a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called for the purpose of proving its execution. If there be an attesting witness alive and subject to the process of the court and capable of giving evidence, provided that it shall not be necessary to call an attesting witness in proof of the execution of any document, not being a will which has been registered in accordance with the provision of the Indian Registration Act 1908, 16 of 1908, unless its execution by the person by whom it purports to have been executed is specially denied. 69. Proof when where no attesting witness found. अगर no such attesting witness can be found, or if the document purports to have been executed in the UK, it must be proved that the attestation of the one attesting witness at least is in his handwriting, and that the signature of the person executing the document is in the handwriting of that person. 70 का है admission of execution by party to attested document. So the admission of a party to an attested document of its execution by himself shall be sufficient proof of its execution against him, through it be a document required by law to be attested. अगला है 71 proof when attesting witness denies the execution. If if the attesting witness denies or does not recollect the execution of the document, its execution may be proved by other evidence. Next, a proof of document not required by law to be attested. An attested document not required by law to be attested may be proved as it was unattested. 73. Comparison of signature, writing, or seal with other admitted or proved in order to ascertain whether a signature, writing, or seal is that of person by whom it purports to have been written, or made any signature, writing, or seal admitted or proved to be satisfaction of the court to have been written or made by the person may be compared with the one which is to be proved, although that signature, writing, or seals has not been produced or proved for any other purpose. The court may direct any person present in court to write any words or figure for the purpose of enabling the court to compare the words or figures or written with any words or figures alleged to have been written by such person. This section applies also with any necessary modification to finger impression. 73A है proof as to verification of digital signature. In order to ascertain whether a digital signature is that of the person by whom it purports to have been affixed, the court may direct that the person or the controller of the certifying authority to produce this digital signature certificate, or any other person to apply the public key listed in the digital signature certificate and verify that digital signature purport to have been affixed by that person. And यहाँ पे जो controller word है उसका mean है controller appointed under subsection 1st of section 17 of IT Act of 2000, Act number 21 of 2000. So that's our section 73 is completed, and now we will start from the section 74 in our next video. So keep watching and keep sharing. Thank you so much. Have a nice day.